What's the tea? Welcome everyone to Trust and Trade, your weekly glimpse into hot topics in the world of antitrust and consumer protection.
Hello everybody, welcome to the new short podcast series sponsored by the Economics Committee, where we hope to give you the highlights of our latest programming.
Your hosts today are Nathan Blalock.
And I am Gabriela Antonie, and joining us today is Megan Browdie.
Megan is a partner at Cooley, where she is focused on antitrust issues, including guiding antitrust transactions through merger review and representing clients in government investigations and litigation. She regularly counsels clients on a variety of topics, including pricing practices, licensing of intellectual property, and other distribution issues. Megan was a moderator on a recent panel hosted by the Economics Committee, where Steve Bronars discussed no poaching restrictions.
So Megan, let's kick it off. I guess, what are no poaching agreements?
Great. Yeah. So first, thanks so much for having me. I'm delighted to be here. And I do think it makes a lot of sense to level set at the outset. The DOJ has defined a no poaching agreement as an agreement among employers not to recruit certain employees or not to compete on terms of compensation that are illegal. So that's when we use the term no poach today, we should be thinking about those types of agreements.
Got it. And Steve described a rather deep well of economics literature on the subject. What stood out to you from the legal perspective as he reviewed those papers?
Yeah. So I think the main thing that stood out to me is that there's still a lot more research to be done. I think Steve's conclusions in the panel really did a great job to sum it up. I mean, no poach agreements and non-competes can be pro-competitive because they do encourage firms to invest in their workers' human capital. On the other hand, no poach agreements can also enhance an employer's monopoly power and depress wages. And it seems, based on what Steve described, that the empirical studies find that greater enforcement of non-competes is associated both with lower wages and lower turnover and more investment in training. So we know that there's some impact and potentially on both sides, but we don't really have a good economic sense yet of how large those benefits and harms are and how we should be balancing them.
Steve also touched on per se cases of no poaching agreements specific to franchises. I guess, how does this issue of per se legality usually play out in real cases?
Yeah, for sure. So there's actually a substantial debate about the right standard for no poach agreements in the franchise context. At least historically, the DOJ has taken the view that in general, a no poach agreement between a franchisor and a franchisee is a vertical restraint, which means basically under the legal framework that it should be evaluated under the rule of reason. That they should not be viewed as a hub and spoke conspiracy unless there is evidence that the individual franchisees agree with each other. So the franchisor should not be considered to be basically creating an agreement between the franchisees. And so again, rule of reason applies. There have been folks on the other side of that debate. So the Washington AG, for example, has called this approach, quote unquote, somewhat misguided. Their argument is that the DOJ should be they should not be analyzing the no poach provisions as ancillary to otherwise vertical or pro-competitive agreements because they're not essential to facilitate the franchise agreement in which they're contained. So the argument that the Washington AG is putting forward is that they are part of a vertical agreement, but they're not fundamental to accomplishing the objective of the franchise agreement. We do know that the Biden recently put out an executive order on promoting competition in the American economy, and that does highlight labor markets as a key focus. And so it is possible that we may see the DOJ's tune change on this, but that all remains to be seen. So that's sort of at the enforcer level. And then looking to court decisions, the courts do suggest that they are open to treating no poach agreements as per se illegal, but it's certainly not yet a consensus view. Got a couple examples. So the Western District of Kentucky in Henry Papa John's employee litigation, they denied a motion to dismiss, concluding that the plaintiffs plausibly alleged that the franchise no poach provisions in the agreement could be found unlawful under per se, quick look, or rule of reason, but did not indeed conclude that they were. The District of New Jersey similarly held that employees who are the plaintiffs in Robinson v. Jackson Hewitt plausibly alleged a no-poach agreement between Jackson Hewitt and its franchisees. But they declined to resolve the applicable mode of analysis because to do so would be premature and more factual information is required. So at least not excluding the possibility of a per se decision. And then in the Eastern District of Pennsylvania, in Fuentes v. Royal Dutch Shell, that court followed the Papa John's holding and concluded that it was at least plausibly alleged there that the employees of the franchise-based car repair company Jiffy Lube alleged that the agreement was an unreasonable horizontal restraint of trade, and again declined to decide what antitrust standard would apply. So I think that sort of tells us that most of the courts are kicking the can down the road until they learn more factually, or hopefully, I think for some of them, somebody else will come to a conclusion or will get more clear guidance out of the regulators.
Got it. And so this concept of the pro-competitive effects from these agreements, seems to be very central to all of this. But to some people, that idea of pro-competitive effects from a no-poaching agreement may seem very unusual. What was your take on what it means for a no-poaching agreement to have pro-competitive effects?
Yeah, for sure. It's a good question. I think it's also, again, very much wrapped up in what the Washington AG was saying that we just talked about. So I think Steve did a really good job of articulating what the arguments are that there are pro-competitive effects. He argued that the no-poach agreement increases the employer's incentives to invest in what he called specific human capital, which he explained is skills and training that are only valuable at a more limited number of employees, as compared to general human capital, which includes skills and training that are valuable at a wide variety of employers. And so his argument, or at least the argument that he articulated, is that if turnover is expected to be high, then employers may invest little in the specific human capital of their employees. So they're not going to invest in those non-transferable skills. And similarly, workers would be reluctant to invest in their own specific human capital if their job security is uncertain. So the argument goes that if no-poach agreements that limit employee turnover could encourage more investment in specific human capital and raise worker productivity to the benefit of both workers and society in general. That said, it's pretty clear that not everyone agrees with that, and the intuition in your question suggests that. I mentioned the Washington AG disagrees on the pro-competitive justifications, and Steve also acknowledged in his discussion that turnover could be reduced through other mechanisms. And so maybe a no-poach agreement isn't required to achieve the benefits of the investment in specific human capital. So examples that he provided of mechanisms that could reduce turnover included bonuses and deferred compensation, but did note that many employees will heavily discount deferred compensation, and so query whether that would be as effective as a straight up no poach agreement. And then I think one issue we should also keep in mind here is pro-competitive vis-a-vis who, right? Is it pro-competitive vis-a-vis the end customer, where employer productivity, if you have better employees when you walk into the store who really know the business, that experience will be better for your end customer? Or is it better, or are we talking about pro-competitive vis-a-vis the wage earner, the employee who may have his or her wages depressed? And I think that's not a question that's really been grappled with yet in the literature, at least as far as what Steve described.
Changing gears slightly, this year, the DOJ brought a criminal no-poaching case. Can you tell us a little bit what is so special about this matter in particular that led to criminal charges?
Yeah, for sure. There are actually two cases now that have been filed in 2021. And the DOJ is bringing these cases as criminal for conduct that occurred after it issued its joint guidance with the FTC in 2016. In the DOJ's view, that put the market on notice that they could be criminally charged And I think what we see out of these two cases is that they really rely very heavily on documents. So maybe the one that you're referring to is the US versus SCA, which stands for Surgical Care Affiliates, which is part of the United Health Group. And in that case, the DOJ alleged that SCA entered into agreements with two unnamed healthcare companies not to solicit each other's senior level employees. And the evidence that they cited in that complaint included an email saying, quote, "I had a conversation with another individual about people, and we reached an agreement that we would not approach each other's proactively," presumably referring to each other's employees proactively. And in another email that was cited in the complaint, a senior HR employee at one company instructed a recruiter, "Please do not schedule a call with a certain candidate. She would have to apply for the job first, and we cannot reach out to SCA folks, take any SCA folks off of the list." And following up on that in February and March, two class action lawsuits were then filed against SCA on similar charges. And just this month, the CEO of one of the other companies, DaVita, was indicted on this matter for this conspiracy, as well as a conspiracy with another competitor. And I think what you can see through this is really like some of these, assuming that you believe that a no poach agreement is a violation, some of the evidence is pretty clear that there was some agreement between the parties, or at least appears clear on its face. And then another criminal case that's been filed this year is US versus He and VDA OC, and that involved both wage fixing and no poach. So a little bit broader than what we're talking about here, but still certainly relevant. And there, the grand jury indicted VDA and Ryan He, both of which were healthcare staffing companies, and alleged that they had agreed not to recruit or hire nurses from the other and not to raise the wages of nurses. Here, the DOJ cited evidence of communications between He and its co-conspirators saying, "Per our conversation, we will not recruit any of your active CCST nurses." So as with other criminal cases, I think what we're seeing here is the more egregious or obvious nature of the conduct. And then there's obviously, in any case that the DOJ brings, they are thinking through what they're going to be able to prove in court. And I think a lot of the documents here are pretty good. I hate to use the term a smoking gun, but they are pretty clear evidence of a no poach agreement here, which I think is what is the fundamental reason that they were brought criminally.
And it sounds like there are also quite a few private action lawsuits out there. Could you provide some updates on where those stand?
Yeah, of course. Then you're right. This is a hot area of enforcement. So we've already talked about no poach in the franchise context and then the DOJ's criminal context. So I'll pause on three ongoing litigations. One is Giordano versus Saks, and that's in the Eastern District of New York. And there, the lawsuit is against Saks, which I'm not sure if we all know, but is a luxury retailer, along with others, including Louis Vuitton, Fendi, Gucci, and Prada. And they allege that the defendant retailers agreed not to hire or attempt to hire Saks's luxury retail employees, which then suppressed compensation, or at least allegedly, and allegedly illegally restricted employee mobility. Another case in the rail supply context, the DOJ there reached a civil settlement with rail suppliers in 2018 over the alleged use of no poach agreement. And now it was follow-on private litigation. And, we're talking real money here. In that follow-on private litigation, it resulted in a almost $49 million settlement for the defendants. And then one that's, to sort of closer to home I'm based in DC, so to my DC home is Seaman versus Duke. And there the allegations were that Duke and UNC agreed not to permit lateral moves of faculty. And the plaintiff there was an assistant professor of radiology at Duke, who accused senior administrators and the deans of agreeing not to hire each other's employees, of for positions of the same rank. And Duke ultimately settled for nearly $55 million in 2019. So we are seeing a lot in the private sector, and we are seeing really significant settlements out of it as well.
Yeah.
So the original guidance issued from the FTC and DOJ that kicked off this new enforcement focus on no poach agreements, that happened in 2016 under the Trump administration. Do you think the Biden administration will have a different approach here?
Yeah, so in maybe one of the unusual areas of agreement between Republicans and Democrats, I think that the Biden administration, if anything, is only going to ramp up antitrust enforcement here. And that is no different in the employment context. Biden has already been pretty vocal against non-compete and no poach agreements. In 2019, he said, quote, "It's simple. Companies should have to compete for workers just like they compete for customers. We should get rid of non-compete clauses and no poaching agreements that do nothing but suppress wages." So that's a pretty obvious bent against no poaching agreements and non-competes. And then in 2020, he echoed that, saying that he would work with Congress to eliminate non-compete agreements, except for the very few that are absolutely necessary, and outright ban all no poaching agreements. And I already mentioned the Biden executive order that highlighted labor markets. He hasn't actually gone so far as to introduce legislation banning no poach agreements just yet. But we will see where that goes down the line. And I think we can say that it is fair to assume that this area is going to remain red hot as far as enforcement from the FTC and DOJ, and probably state attorneys general as well, for the foreseeable future. So this will not be the last time that we hear a panel on these issues. And I hope to hear lots of things out of the Economics Committee on a going forward basis.
Well, we're looking forward to having you back here to discuss the newest developments. And Megan, thank you so much for this very useful summary, and for the rest of our audience for joining us today. A reminder for our audience that we'll be posting a link to the full panel where Megan was a moderator on the ABA website. And we'll add that link in the podcast notes. And thank you again all for joining, and we hope to see you next time.
We hope you enjoyed this episode of Trust and Trade, brought to you as always by the Antitrust Law Section of the American Bar Association. Now you know that's the T.